Hi, I am really excited to have Bernadette Meyler here with us today. Bernie got her PhD in English at UCI and her JD at Stanford Law School, and she is now the Carl and Sheila Spaeth Professor of Law with a courtesy appointment in English at Stanford. And she is just doing amazing work there, and I thought you guys would love to hear about some of her projects. So Bernie, welcome to UCI. Welcome back. It's really nice to see you.
So glad to be here. I wish I could be there in person.
We do too, but that will happen. And I want to congratulate you, first of all, on receiving the Guggenheim. That's such an incredible honor. And also to congratulate you on the publication of your fantastic book, Theaters of Pardoning, which began as your dissertation here at UCI, but has really evolved over the years into a much broader study of law and literature. Can you show us the book?
Thank you, Julia. Here it is.
Yay, it's so beautiful.
I bear a lot of responsibility for the creation of this book as my advisor, so I'm continuously grateful to you for that.
Oh, that's so sweet. So tell us what you mean by the theater of pardoning. What does theater have to do with acts of judicial pardon?
It's a great question. And I would say that pardoning is inherently a theatrical act. I think that we can actually see that most clearly from our contemporary moment, where President Trump has deployed the inherent capacity of the pardon power for theatricality to great effect. He's not only chosen to pardon very prominent individuals who he either knows or has seen on TV, but he's also selected very important moments at which to exercise his pardon power. So if he sees that the news cycle is flagging, or if there's something he needs to distract from, he'll choose that time to stage a pardon. And the pardon itself also has a kind of symbolic force in his actions because it signals an objection to a particular form of legality or a particular kind of law. Michel Foucault talks about kind of the pardon arriving in the form of a letter, right? So it seems to be a kind of written object interrupting a particular stage drama sometimes, and that it always arrives just in time or arrives at the very last minute, sometimes too late, and that timing is part of its theater. So I think that in the plays that I talk about in Theaters of Pardoning, pardoning both has a thematic component where it's about exercises of mercy and who deserves mercy and who doesn't, but it also has a genre aspect. So these pardons are all coming at the end of plays to change the play in a way from being a tragedy to a comedy, or being something that might have the threat of tragedy into having a happy ending. And that effect of the pardon to change and shift the mood for the audience and shift their perceptions, I think, is a crucial part of the theater of pardoning.
Wow. So how did Shakespeare participate in the theater of pardoning? Where do you see the pardon affecting his dramas?
So Shakespeare, again, both uses pardoning thematically and as a genre technique. So in plays like Measure for Measure, or The Merchant of Venice, or even The Winter's Tale, the pardon operates to render the play more tragicomic, or to make it less of a tragedy and more of a comedy. At the same time, Shakespeare is also playing with the relationship between legality and mercy in a lot of contexts. And that's, as you know, very prominently an issue in Merchant of Venice with the discussions of mercy that Portia raises, but it also comes up elsewhere in Shakespeare's work. And there's a way in which Shakespeare really stages the relationship between interpersonal forgiveness and the ability of one person to forgive another, and the relationship between that and the political sphere. So what happens when you change forgiveness into something that's given by a sovereign from above, and that is reasserting that sovereign's power, as opposed to reconciling two people who are in some form of controversy. And he's also very interested, I think, in the relationship within the early modern period between what we think of as common law and equity. Common law was the general legal framework that was being applied by the courts, and the ideas that it kind of created an unwritten constitution or an ancient constitution within the early 17th century that jurists would refer to, even though it wasn't written in any particular set of treatises. And then on the other hand, the courts of equity or equitable procedures, which were partly expressed by Chancery, but also other courts of equity, and also used a different mode of legal interpretation and legal understanding, and were emphasizing both mercy and also flexibility of interpreting the laws. So,
well, it just makes me think about so much, including our own hermeneutic equity, our own creativity in response to the changing meanings of Shakespeare's own texts. How has your work in English literature shaped you as a law professor? How do you use your background in English in the law classroom?
I think it's had a profound effect on me. And it's been really interesting to me also to see in my students who have a training in literature, the difference in their kind of approach to legal problems. So I would say that both as a legal scholar and a teacher, it's made me much more attuned to the nuances of texts. One class that I teach regularly is first year constitutional law, and that involves the kind of structure of the Constitution. But as you know, the law school method of approaching instruction, especially in the first year, is through looking at particular cases. And I try to really get students to think a lot more about the rhetoric of those cases and how that rhetoric affects what a justice is actually doing or what a particular case is accomplishing, and think about style and the significance of style within judicial decision-making, and particularly in constitutional decision-making. And I would say that that's, kind of affects my next book project, which is, or that I'm completing this year, on originalism, which is about dynamics of originalist constitutional interpretation and things that originalists leave out and maybe don't account for. But in writing that book, I've been sort of thinking about the fact that Justice Scalia, who was one of the pioneers of originalism, his father was an English professor and was in fact a new critic. And so how did that affect Scalia's understanding of what a text was and what it meant to do interpretation? So,
fantastic. I know you've published an important collection on law and the humanities. What do you see as the next directions for law and humanities in this upcoming decade?
So the collection that I co-edited with Simon Stern and Max Delmar really tries to focus on different ways of seeing the relationship between law and the humanities. So theoretical approaches that can inform both law and the humanities, or come largely from the humanities and can inform law, although some also come from law. But then another section of it really deals with genres. And I think that the attention to not only, text and interpretation, but in particular, the significance of genre is something that legal scholars haven't really been sufficiently focused on in large part. And now I think there's a kind of emergence of interest in, well, what does it mean to have a treatise, right? Or what is a treatise doing differently than a case? That I think in classic work on law and literature, there hasn't been as much attention either to a global dimension or to race and ethnicity as there could be. And I think that it's largely been a kind of Anglo-American movement. And so I'm writing an introduction to law and literature now, where I'm trying to broaden out a bit what we're thinking about in terms of the kind of global reach of law and literature. And then also, I think the role of identity in law and literature. I think a lot of scholars who I think of as working on law and literature, who work on race or ethnicity, don't necessarily consider themselves to be working in that paradigm. And so I'd love for us to see law and humanities more broadly as including that body of work.
Wow, it's so exciting to hear you talk about these things. We're really happy that you have agreed to participate in this year's Shakespeare Trial with Erwin Chemerinsky. I'm just curious to know, have you ever contributed to anything like this? And what do you hope to get out of this new experience?
The short answer is I've never done anything like this before, and I'm so excited at the opportunity. So thank you for inviting me to do it. The only thing that and it may seem like a strange analogy, but that I think of as analogous is that I used to sponsor Supreme Court case reading groups with people from a diverse variety of perspectives and different disciplinary training, mostly not lawyers. And we would just each time take a case and think about it and just talk about the issues that it raised, not necessarily in a legal way, but just inviting all the perspectives that might come into it. And I found that to be extremely illuminating in terms of thinking about how the law kind of fits into the fabric of society. And so in a way, I see the trial as kind of bringing the law to bear on these moral and ethical questions and asking a similar set of questions from a different direction by saying, well, how do we cash this out, in terms of a kind of formal legal analysis? How would we put all of these different conceptual buckets together and cash it out in a formal trial? So I'm excited about that. I'm also really excited about Julius Caesar, because I think it's a play that really raises questions of the relationship between personal responsibility and character and political structures. And I'm also, kind of embarking on a project on majoritarianism. And I think that, this is a play that will be really interesting from that perspective also. So I couldn't be more excited to do this.
Great. Well, we'll have you online again in March for the Shakespeare Trial. Thank you so much, Bernie Meyler.